Hi there, this is Nathan Mullo. I'm a real estate expert. I help out people that are in distressed situations. And so today we're going to talk about judges. Ooh, tricky subject. Hope I don't get in trouble with this. But there are some times where judges have conflicts of interest and the public isn't aware of it. You kind of go into an ambush. So we're going to get into it. So I've had people call me and I review their situation. I am not an attorney. Let's get that straight. Disclaimer, not an attorney, but I have done a lot of work when it comes to properties in foreclosure and different type of cases. So I kind of know what I'm looking at. And I find that sometimes the judges post a conflict of interest after entering a judgment for the plaintiff. You imagine they waited to enter the judgment against the homeowner, and then they post a conflict of interest. And then this is the next big surprise. Of course, these things are e-filed, right? It's in the docket, e-filed by the judge. That means your defense attorney also got a copy. But a lot of times your defense attorney won't even tell you because he starts looking out for the judge. Why? Because he's got to work in that building with other customers in front of the same judge and doesn't want the judge to be upset with him. You imagine you as a homeowner, you find out much later that your own lawyer knew there was a conflict of interest and never told you. So if you're in that situation, make sure you fire your attorney and you motion to recuse the judge. Get a court reporter, get it all, an official record, and once you get rid of the judge, then you can get a new judge, and you should be able to vacate the last order, which was the judgment. So that's a good thing. So when you find that, don't hesitate. Just go ahead and fire your attorney. He didn't tell you, right? So you need someone that's willing to call a spade a spade. So I'm going to show you an article here that I came across, and this is about a homeowner that found out that there was a conflict of interest with an appeals case. So here it is. They went to an appeals case after their trial, and then the appeals court ruled against them. And so they challenged that, and so they won. So federal judges plead guilty. Think about that. Plead guilty. They were in business with the bank when they ruled in favor of the bank. They should have disclosed this. Yeah. Bam. Good. Well, you know what? Serves them right. They're supposed to disclose this stuff from the very beginning and recuse themselves from the very beginning, and they're not doing it. They're trying to hook up their business partners. They're looking out for the banks, but they're not disclosing this to the public. You have a right to know this thing, and they're hiding it from you. Not good. So how extensive is this? Well, it kind of seems like it's more extensive in certain places than others. I'll give you a big one here. In the 3rd DCA, which is where I'm located, we have 5 appeals courts in Florida. The 3rd DCA is notorious for ruling against the homeowner. So somebody, an attorney, reviewed the stats, and here's what you got. Check this out. You have the 1st DCA ruling in favor of homeowners, 83%. The 2nd DCA, 83%. The 3rd DCA, 12%. Really? That means 87% in favor of the bank, whatever issues come to the appeals court. 4th DCA, 72, 5th DCA, 71. So you have this huge anomaly here where the 3rd DCA, 3rd District Court of Appeal, seems to rule a high percentage of time for the banks. So even when you're right as a homeowner, you say, hey, I have rights. The trial court messed up. I'm going to appeal. Well, you're walking into something of an ambush, right? So, yeah. So down here, the people that are in this fight, I'm in this fight, I'm very aware of it. And it's like, what's the point of going there? Because that appeals court is kind of stacked against you. And so I'm glad this attorney came out with the stats. Now, I got to tell you this, that's another issue. When you find something like that, normally you would be allowed to present your motion and have it your case moved to a different jurisdiction, right? And another attorney, not Rosen here, but another attorney tried doing exactly that. Presented the stats, said we'd like to move it to another jurisdiction, and the appeals court came down hard, literally saying that lawyer was questioning the integrity of the court, and they weren't going to have it. And they filed a bar complaint against him. You imagine? Filed a bar complaint against him, threatened to have him suspended, lose his license, you name it, and they leaked it to the newspapers. Somehow it got leaked to the newspapers, and all sorts of heat. And a lot of people found out about that, And so I see that as they're trying to discourage any other attorney from making that argument by trying to ridicule him in public. I don't like stuff like that. That goes to show you that it's like dirtier than you even thought, right? When they leak it out to the newspapers to make him look like the bad guy when he didn't do anything wrong, he's just kind of presenting facts. Stats don't lie. So, so I catch this stuff. And the next thing I'm going to show you is the trend in what we got going on here in Florida when it comes to foreclosure cases. All right, so we have sometimes the judges having conflicts of interests, but how about all cases? Well, this is back in 2013. 2013, there was a ton of foreclosure cases, ton. So they did put a committee together. They reviewed what takes so long, why is it dragging out, and they've come up with approaches to speed up the cases. So you see more case management with the older cases, more focused attention on that, using technology to speed it up, all of that. And so they really want the chief judge to be responsible for closing out all these old cases. Well, that's great and all, but so how do you know you're getting your fair shake in the courtroom? I don't know. I get worried about them when they're trying to expedite. Expedite seems to be like steamroll the homeowners all around Florida. Now I got to tell you this: they have made it a whole lot easier to foreclose on the public, because really all the banks need at this point is just an endorsed promissory note. Doesn't have to be endorsed anyway. It's just endorsed in blank on any particular day. It doesn't really matter, and that's good enough. It's like a signed blank check. That's the way they look at it. So it's a whole lot easier to get foreclosed, for the banks to get the foreclosures, and then on your end, it's harder for you to defend yourself. And on top of that, what I am seeing is they're trying to line up everything for summary judgment anyway. So you can really, like, you're walking into a very fast-moving situation. So anyone that's like going into the foreclosure process now, I got to tell you, you have to make your game plan up front of how you want to resolve this, and don't start assuming it's going to be like the past, because they're pretty set up at this point to deal with these cases and run them through and get them done. I've seen cases get done in less than 12 months. I mean, super fast. So yeah, don't wait too long. I try to help out the public. This is what I do. I have a passion for it, and if you have trouble with your property in any way, just give me a call and I'll review what's there, and I'll try to give you a good, accurate opinion of what you can do. And if I can help you out, I'll tell you that, and I'll take care of it. So I look forward to talking to you. Bye.